number 70, matter of City of Long Beach versus the Public Employment Relations Board. Counsel?
Thank you, Your Honor. May I reserve 2 minutes for rebuttal?
2 minutes? Yes.
Please. I'm Michael Foyce. I'm the General Counsel of the New York State Public Employment Relations Board. To start off, want to point out what is not in dispute here, which is that the appellate division's ruling cannot be affirmed on the appellate division decision. There's absolutely nothing in the decision this court can hang on to in order to affirm that decision.
So should we just send it back for a redo?
That is one of your possibilities, I think, in the interest of judicial economy, since it's fully briefed and it is before this court, it would be appropriate for the court to decide the issue. But as we're saying, we agree that the regulations the lower court relied upon do not apply to employees of the City of Long Beach. And it's also undisputed that in the decision, no specific language in CSL 71 itself was identified by the court. Our position is clear that the numerous precedents of this court, Watertown, Auburn, Schenectady, Board of Education, set forth very directly that the strong sweeping policy in favor of collective bargaining means procedures to implement the statute are bargainable unless there's something explicit in the statute preventing it or clearly inescapably implicit.
So what would the legislature, from your view, what would the legislature have had to have done?
Well, I
To
think
say that this, what you're arguing for is not negotiable.
I think I will use Schenectady as an example. In Schenectady, one of the issues, the key issue was whether in order to be eligible for light duty, the municipality can require ongoing medical treatment. There were other issues in there as well, such as notice and what have you. This court, looking at it, said since the statute itself refers to surgery and continuing medical treatment, it was clear that the legislature did not intend a municipality to have to bargain over procedures regarding surgery or continuing medical care. That same opinion, however, took pains to point out that even though not in front of the court at that matter, there were other procedures pursuant to the statute that may be negotiable, such as the review of medical records, whether the medical records relied upon by the municipality making their determination.
So, for example, if you look at Civil Service Law 71 itself, it has some, you can call them post-termination or perhaps call them reinstatement type of provisions. One little piece of that is that the department or commission selects a medical examiner. Is that bargainable or not bargainable?
I don't think, because a specific issue wasn't put before PERB, I can't pre-guess a case. But based on the precedent, I would say not bargainable because not disputed in this case that the decision whether or not to terminate is discretionary and resides with the employer. And not only...
Let me ask you then a follow-up to that. The provisions about post-termination or reinstatement have a one-year period of time after the disability, right, during which these various protections exist. Would it be bargainable or not bargainable if the union wanted to bargain about reinstatement after 3 years, let's say, from the termination of the disability?
I believe so, because we want to maximize the flexibility.
Is bargainable or not bargainable?
I would say it is, because we want to maximize the flexibility of the parties, including employers. One example I would use is, this case does not concern hearings. We're not saying hearings were required. Your case law says hearings are not required as a matter of minimum due process. But it is very common for the parties to choose to negotiate and agree to hearings in certain circumstances. In other words, if an employer wants to, for good labor relations or for whatever reason, agree to say even more than a year later we'll continue reinstatement.
Counsel, going to this point here, I think it's your brief. You say the employer's right to terminate under Section 71 and its right to choose who makes that determination are not at issue. The sole issue is whether under the Taylor law, an employer is required to bargain over pre-termination procedures, right?
Correct.
But in your decision below, in the PERB decision below, and in this particularly citing Cortland, it seems like you are saying that who makes the decision is bargainable.
Well, with all due respect, I believe that's a misreading of Cortland. We are most certainly not in Cortland or any of the similar cases under the various other civil law sections did PERB ever say that the decision maker can be controlled, is a required aspect of bargaining. What we did recognize is that procedures related to it, which may impact on who the employer chooses to be the decision maker, or the employer may agree as to who the decision maker is. But we most definitely have never said that who the decision maker as to whether or not to terminate someone is subject to mandatory bargaining. That resides with the municipality.
Can I go back to Judge Wilson's question about the 3-year termination negotiation? Is there any problem here in that this statute specifically refers to a 1-year timeline? Granted, it's permissive, it's may, not must. But it would seem to contradict in at least the spirit that the legislation seems to be written in.
With all due respect, Your Honor, I couldn't disagree more. If they didn't want to give the employer the freedom to keep someone out for more than a year or to consider reinstating them after 3 years, they wouldn't have made it discretionary. They did not say, because of labor problems in the state of New York, if you're out for a year, the municipality has to let the person go and then go through the civil service process to replace.
What about the fact that there's a presumption in favor of collective bargaining unless there's legislative intent to remove that issue from mandatory bargaining that is plain and clear?
I couldn't agree.
Where is that here?
There's nothing that's plain and clear. The parties agree that the legislation is silent as to it, and I believe it was Auburn, but its case is cited in our briefs, where this court held that where the statute is silent, you cannot presume or imply a legislative intent to prohibit collective bargaining. There is no pertinent legislative history. Section 71's legislative history doesn't go anywhere near this, and the similar statute they relied on predates the Taylor law. And once again, this court has basically said as a matter of statutory construction, you can't look to case legislative history older than the Taylor law to try to get an idea of what the legislature was thinking about collective bargaining. Obviously, if there was a more recent amendment, that legislative history would clearly be considerable. But I'd say there is nothing.
But your interpretation does appear, and maybe there's a response to it, does appear to undermine the legislative goal of expeditious termination.
Absolutely not. This is parties have to negotiate one time, and critically, they do not have to wait until they want to terminate an individual. In 1997, Cortland was confirmed by the courts. Since 1997, it's not only been per precedent, but court-confirmed precedent that Section 71 procedures are bargainable. They had 25 years. They waited until after a year, after they wanted to terminate someone, to give the first notice to anyone that they consider doing those.
Well, you say they only have to do it once. Perhaps I've misunderstood. Every time the collective bargaining agreement expires, don't they have to renegotiate?
Yes, but the prior existing procedures stay in effect until you negotiate new ones.
Yes, but all I'm saying is it would be open to negotiation again. It's not that you negotiate it once forever and now both sides, because it may very well be employees are seeking a reconsideration of whatever they've negotiated, right? You're
Absolutely.
not necessarily bound to it for a future agreement. The parties might renegotiate.
Absolutely, but the harms the city keeps going at about we can't replace the employee or the time it will take, these are myths. This is a one-time thing. So the goals of the statute are not frustrated by having to negotiate the first-time procedures to be put in place.
Thank you, counsel.
Thank you very much.
Your Honors, if I may reserve 3 minutes for rebuttal?
You may.
Thank you. If it may please the court, my name is Louis D. Stober Jr. I'm attorney for the City of Long Beach Professional Firefighters. Had to make sure I put that junior in there so that my son, Louis D. Stober III, who this is his second day as an ADA in the Nassau DA's office, so we have that distinction between father and son, but very proud of him. I'm going to try to be concise, quick, and to the point here since you've asked questions of Mr. Foy on behalf of PERB. If you look at the Appellate Division decision, it can be broken down as follows. They did not mention legislative history as a rationale. They did not mention public policy as their rationale. They did not mention that there's a clear and present indication, either expressly or implicitly, prohibiting negotiations. Instead, what they said was, Section 71 has no pre-termination procedures. Section 6(1) of the Civil Service Law allows civil service to promulgate rules to implement this chapter, meaning the entire Civil Service Law. They then jump to say, and the New York State Department of Civil Service enacted Section 5.9, setting forth rights under Section 71. Therefore, number 4, there's no need for negotiations. There's 2 critical flaws with that analysis.
Let me interrupt you. I mean, it does seem, sort of following up with some of the questioning of
Sure.
Ms. Foy's, it does seem that what the legislature is trying to do is balance the employees' interests and needs and the employer's interests and needs. And it looks like when they did that, they decided, okay, there'll be this 1-year period, but after that, if the employer wishes to terminate,
They can do so.
terminate, and you want to expedite that, because you've already waited a certain period of time to get to that point.
And all we are saying is, fine, but the procedure for getting there is mandatorily negotiable. Is an email to the employee sufficient?
But doesn't the procedure extend that period of time that the legislature is already in that balance,
I would disagree.
weighed in a particular way and come out with a particular
I would disagree, Your
timeframe?
Honor.
I mean-
There can be procedure that says 30 days prior to the 1 year, you have to notify the employee. The employee must within 10 days object. An opportunity be
Well,
heard, must be heard within
You could have a different procedure
that.
that's
So
quite
that you-
lengthy, that involves appellate practice, there might very well expand this way beyond what the legislature ever intended.
But you know, the legislature is astute. I've been practicing for 38 years. I know collective bargaining takes time. The legislature knows that too. And yet there's not a single statute that says, you know what? We are going to prohibit negotiations if it's going to take an extended time to get there. If there's 6 months or longer to get to a collective agreement on this, then you don't have to do it. They didn't do that. They know, we know, and the City of Long Beach nor any other municipal employer has ever prevailed upon the legislature and the governor to enact legislation that would prohibit collective bargaining if it takes a long
Well, the
time to
collective
get there.
bargaining may take a period of time. The question is whether or not what you end up bargaining for undermines the original intent of allowing the employer, after a set period of time, to be able to terminate, get an employee in, and move on with the
You know,
business.
but even if in the city's best case, they were to notify the employee and then give them their opportunity to be heard, it's going to be more than a year anyway. And frankly, if somebody's on Section 71, that means they're on workers' comp. They're not on salary. They're receiving workers' comp benefits. So the benefit to the employer is not there that, oh, we're keeping them on salary. We're keeping them on workers' comp.
Counsel, do you agree with your colleague that the issues here are circumscribed to pre-termination procedures?
Yes. And the problem, as I was about to say, the 2 flaws that I see with the appellate division decision is, one, they relied on a rule that doesn't apply to Long Beach firefighters. The city, in their brief, spent many pages on that exact point. And there is no rule or regulation in Long Beach Civil Service Commission on Section 71. And secondly, the appellate division's decision, I'm sorry, the red light just came on. The appellate division's decision does not take account of the numerous cases, including Newberg, that says that a rule or regulation cannot supersede a legislative enactment such as here that says that this is collective bargaining. And the policy in the state of New York is a sweeping policy of collective negotiations. And I thank your honors for giving me this opportunity to speak to you, and I look forward to seeing you on rebuttal.
Good luck to your son.
Oh, thank you.
Thank you.
Good afternoon, Your Honors. Three things first, so I don't forget to do them later. Cortland was not affirmed by the courts. It went to the Supreme Court, Westchester County, that's it, no appellate review of that. Number two, the rules that we're dealing with here, ironically, we have Mr. Stober to thank for that. They were submitted post-oral argument in the appellate division. That issue was raised. Cook was raised by him post, and we had no right to submit any more papers. So that's why the appellate division definitely was confused on that issue, because they do not apply, no question about it. The third thing is, and I don't ever do this, but I've been practicing 52 years. He said 36, so I don't usually tell people, but I will tell you today. So this statute, in all those years, with all the cities, villages, towns I've represented, this is one of the most damaging statutes and so contrary to the legislative history. The legislative history of this statute could not be any clearer. Pre-Taylor law, back in the 60s, and they said, we have to do something because when people get sick for extended periods of time, we can't go without them because it puts too much of a burden on the people who are still left, or we have to get replacements, and God forbid you try to get replacements
Do
nowadays
you
for
have a
workers.
sense of how widespread this issue is, of employees being in this particular situation and the employer really needing to replace them, wanting to bring someone in, potentially losing someone because they have to wait?
Well, with the fiscal the problems they have, every time someone goes out on workers' comp, we're down one person. That's like a police department, because that's the easiest. They don't go without that person. They have to have people work overtime, and you're talking about a year, and it's a strain on them, and I must say, the younger generation, in the early days, you couldn't get enough overtime for the cops. Now it's hard to get cops who want to work
Let me
overtime.
direct you
Counsel, I
back to
cer-
the legislative history for a second.
Yeah.
Because it seems to me that the legislative history expresses two different concerns. One is the one you stated, right? We need to have people in the jobs. But the special concern that's stated in the legislative history is that people who are mentally ill and unable to perform in the job because of a either temporary or longer-running mental illness would be stigmatized by a process under Section 75 that would designate them either incompetent or, I've forgotten what the other word is, or guilty of misconduct. And it troubled me, I have to say, that in the long block quote of the legislative history you have at page 15 of your brief, you twice elided the references to mental illness, which seemed to be the legislature's special concern. So at least as I read the whole legislative history, it seemed to me there were dual concerns, right? One concern was we need to have people in the job so the work can continue. But the other concern that the legislature says especially about is the stigma attached to using 75 for people who are mentally ill. What do you say about that?
It was not just for mentally ill, Your Honor. It was in there. It was mentally ill was mentioned very much at the end. But the overall problem, how many mentally ill people do you have on workers' comp? It has to be caused by working on the job. Doesn't happen very often. I haven't had many cases in my lifetime. But there's a lot of physical injuries to people.
Why did you elide the two references to mental illness from the legislative?
I'm sorry, I didn't,
Why did you remove those when you quoted the legislative history?
about the mentally ill?
Yeah.
I actually thought it was something that I never dealt with, I'd never heard of. I had never had a case where we had somebody out because they, on workers' comp, the mental illness was caused by the employer. I've never heard of even a case like that. And most of them are all physical injuries, and they're out for a year, and the problems, in fact, the legislative history says at the end, it's the public policy of the state to make sure we fix this problem by putting this in. It was a serious problem, and it's one of the last paragraphs they mention before the mental illness part, that this is a very serious problem, and the stigma about 75 is true. And now, again, I'm jumping ahead a bit, but now we're back in there because of what happened in Southold. They didn't want to go.
So is it clear here in the legislation that there was an intent to remove this from collective bargaining?
Well, it couldn't have been the intent then because it wasn't collective bargaining. But I have a list of cases somewhere in this pile of all of the cases this court has overturned of PERB, when they keep saying the Court of Appeals can't overturn PERB's decisions. There's a list of about a dozen of them, and about a half a dozen of them involve statutes that existed before the Taylor Law was drafted. So you have to, and in this case, when they talk about the importance of this, I've seen it, and now we don't have to guess anymore.
But
We've seen what
this is
bargaining
a-
leads to, 3
Counsel-
years without a worker.
It's a statute that provides for termination, and it would seem that there has to be some process, some procedure around how you effectuate that termination right. Your argument surely isn't that they could just send a pink slip to an employee after 1 year and tell them it's time to go. Is that your argument?
It happens to be a no-fault statute. If they did something wrong, we have Section 75, and that has all the pre-hearing protection you need: charges, attorneys, people present at the meeting,
This
hearings.
theoretically covers a different class of employees than 75. I mean,
No, same people. All civil servants.
But the
But
no,
Counselor
no,
Wood,
It's a different type of, these are workers who are out due to injury, not workers who are being terminated for any of the causes that are specified under 75.
Well, the people who were taken out in Southold were taken out on 75 charges because they weren't able to work. They hadn't worked, one of them, for 4.5 years.
75 is available, but 71 is there now as well. It provides another avenue to terminate this particular type of employee after a year's absence from the job.
You're-
And my only question is, there has to be some process around how you do that, does there not?
Your Honor, I've done a lot of these in my history, and they're seamless. I don't have one where we've negotiated a procedure, and the only thing that's in the record is that Mr. Stober told somebody that Nassau County has negotiated 71 procedures. We don't have anything in the record other than his statement. I can tell you on the record, I've never negotiated one in
But
52
the
years.
reality is, there was a procedure here. They're just arguing that it's not the one that anybody negotiated.
He
It was
got a
one
letter.
employer imposed. So this is actually not a case about no procedure being used to terminate the individual. This is
Well,
only whether or not the procedure that the employer is going to adopt and impose should be one that is collectively bargained. That's the question on the table.
Well, let's talk about what you say is a procedure. The person who is the commissioner sent a letter,
Yeah, that's called notice.
notice, and gave
Said
an
if you have
opportunity to be
anything to s-
heard.
that's
There's
what
no hearing in this case. Your own summary of this case mentions the hearing.
But that's an attempt at minimal due process, is it not?
Exactly what it was, under
Okay.
Loudermill and under many subsequent
But
cases.
that's a
That
procedure.
It's
It's a procedure.
procedural,
It may not be the one they want, but
correct.
it's a procedure.
There's a procedure, they get notice, opportunity to be heard, and then,
Yeah.
and it's again, it's a no fault. After the year, they can be removed so that we can address all the things we talked about before, getting someone else in
Well,
there, the
True no
overtime,
fault is you're
the
fired.
morale.
True no fault is here's a letter, you're terminated, period. Not I want to hear anything, not you have an opportunity to respond, right?
Well, here, you'd be taking away someone's job, and I think
Well, I think then your response to the judge, of course, is that yes, there's a procedure, it's just not negotiable. Right? I think he
Well,
was asking you,
I don't-
I thought, I may have misunderstood the judge, he will correct me if I'm wrong.
You did not misunderstand.
I thought his point was, there has to be some procedure. And that, he wanted to confirm with you that you were agreeing that there should be a procedure,
Well,
not that, that this is, Section 71 doesn't allow for any procedure.
if you want to call it a procedure, what happened in this case is that letter looked very familiar to me. I represent the city of Long Beach. So it put the person on notice of what we intended to do and gave him an opportunity to be heard because he has a constitutional right to his job. And that's all that statute calls for. It's a no-fault statute. For better or worse, we didn't write the statute, but there was a terrible problem that the legislature addressed by people being not coming to work.
This reference to no-fault statute seems to imply that the process is automatic, but the statute itself says may terminate, not must terminate. And I think what Judge Rivera characterized as a minimal amount of due process, sending a letter and giving an opportunity to be heard, is at least implicitly a recognition of the fact that it's not no fault in the sense that it happens automatically. Certainly not the case that every employee who's been out on disability for a year gets terminated. You've never alleged that, and I don't think the reality bears that out, correct?
Correct.
So this goes back to the question I was asking, which is, and I think Judge Rivera actually hit on the point, you did set up a procedure. It just may not be the procedure that the other side wants, and now we have to figure out a way to get to a procedure that applies equally to both, and why isn't that the Taylor law? Why isn't that negotiation?
Your Honor, to me, maybe we disagree. A letter and a meeting is not a procedure to me. It's notice under the Constitution
But
that you're
it's
required to
something
give
that,
an opportunity to be heard.
Counselor, it's something that triggered a process wherein this employee was going to be removed from their position. That's what that letter did.
No, the letter did not. It set up the
It
meeting.
started a process. It started something. If the letter didn't go out, would the employee remain employed?
If my client were asking for my advice, I would send a letter to put him on notice that we're going to take your job away under a no-fault statute.
So your position is that that the statute is such that you just get to exercise, not may, that at the end of the year, they are gone, period, the end. There's no process or procedure required.
There is a process. None of my clients have ever done that because we have a Constitution and they have a liberty interest in their job. So we put them on notice and we give them an opportunity to respond. No hearing, people say there was a hearing. There was no hearing. It was a
Because the
meeting. And
year
that
has
person-
passed.
I'm sorry?
Because your argument is,
Correct.
because the year has passed, that's it. It's not showing that they were guilty of misconduct or anything else like the Article 75
Correct.
would.
Yeah, but Counselor, would a negotiated 71 procedure really impact the efficiency of termination of employees? Like, what's the practical impact of that?
Your Honor, I was thinking of all these hypotheticals as I'm going through this process about how awful it was for my employers. Well, I don't have to do any hypotheticals anymore. We've got it. City of Yonkers, I've represented them at one time in my life also. 5 years they've been going. The process of the negotiations has been 3-something years. Before that, they had 2 more years at it. Now, all that time, that firefighter is being paid 100-something thousands of dollars, and they replace firefighters like they replace cops. You're out, someone gets overtime. It's cost them millions of dollars already. That to me, that's why they don't have these procedures. That's why they weren't in the statute.
But
There's
isn't that
nothing
really,
to be,
Counsel, isn't that really an argument to the legislature? To say, look, you've got to carve this out, because this is just too financially burdensome for us.
no, I have the legislation. It's in existence right now. PERB is trying to stop it by allowing unions to slow it down.
So
And that's what they've done.
Can I turn you back to to Section 75 for a minute, which has hearing requirements and other procedural protections, right?
I'm sorry, I can't,
Section 75.
75, I understand that part.
It has a bunch of procedural protections in it,
Yeah.
including hearing requirements. Are those, in your view, not bargainable?
That's a for-cause statute, and they have all the
I'm just-
pre-termination.
simple
Yeah,
question.
75, yes, they could negotiate an
They
alternative to
can
75.
bargain those, that's a bargainable subject?
75?
Yeah.
Yeah, yes.
I think the question is, the procedures that are
But,
laid out in
excuse me,
75.
that statute would be in place while your bargaining was going on. Here, the people are working.
No, my question is, is it a mandatory subject of bargaining such that the employer and union could bargain away the provisions that are in Section 75, the procedural? You
I
think-
believe it is.
you
They
think
can
there are
negotiate
bargains?
a substitute for it.
Could they negotiate something that's less protective of the employee?
Of the employees, if the union would agree to it.
So now I'm having a lot of trouble, because it seems to me you're saying when the legislature set out a specific set of procedural protections, that's a mandatory subject of bargaining. But when they've said nothing, as they did in Section 71, concerning anything pre-termination, that can't be bargained.
Well, think of the issues in a 75. Cause. There's no definition of cause. You got to prove it. Here, you know what you need for one of these hearings? A workers' comp decision, which every employer I've ever dealt with has one, because now it shows that it's on-the-job injury. And on the second hand, they have a calendar. That's all they need. Had they been out for a year under that, that's the end of the case. That's why there's so minimal due process. The issues here, it's a very pro-employer, good statute that saves people from having workers. And, I brought it up in the appellate division, too, when I was arguing with the judges. I said, let's say you had a clerk who all of a sudden now is sick, and they're out for 6 months, 7 months, 8 months, 9 months, a year. Your life gets pretty difficult. So the legislature decided, before the Taylor law, that, not only that, the burden that falls on the others is not good, and you got to get workers, and they're hard to get, and if you have a full-time job to replace them, you can get good workers. So they put this legislation in, and again, these are people who, usually we don't have issues with people who are malingerers at that stage. They either get back to work before a year, or we let them loose. And they have a very, very long post-termination procedure about steps you can take to get your job back. So it's not like it's lost forever, so it's not unfair. It gives an opportunity to get it back if the person gets healthy again. Almost every one of my cases in my career, people have retired after they were removed under 71. The most recent one I have, which is a long career, I had one recently where a guy came back after being released under 71, didn't retire, and is back working. The first one I've had in 50-something years.
Thank
So
you,
it's not as
counsel.
bad. Thank you. I'll save all this now for Lori Garland.
Thank you, Your Honor. In the 70-some-odd years of the Taylor law, no court has held that the time it takes to bargain or the difficulties in bargaining are grounds to remove something from collective bargaining. And relying primarily on his own experience as an attorney, as opposed to giving you specific case sites, he's saying this is an impossibility. An employer cannot refuse to bargain and then complain to the courts, it takes so long to
Counsel,
bargain.
that's not really his argument. His argument is because of that, that goes against the statute here. This particular statute, not in general, not a general proposition, but he's making that argument in support of an argument that the legislature decided this, and it's not bargainable because the purpose of the statute is to prevent exactly that delay. So to get to that point, what happens, and I just don't know this, what happens if, in this case, negotiations just break down and they can't come to an agreement over process? Your point that this concerns the procedure, what's the remedy? Like, how does that get moving?
They have what's known as impasse arbitration procedures for the uniform in this circumstance, which means the party who believes the other side is not properly responding goes and say, we're at impasse. Then an arbitrator chosen by the parties from a panel reviews the material and reaches a decision, and issues an arbitration award. If one side doesn't like the arbitration award, they can go to court. And that's what happened in Yonkers, the case that just last week was brought to the court's attention, although decided in December of last year. In that case, the employer, like here, argued public policy should not allow bargaining over pre-termination Section 71 procedures, and the court found no public policy grounds not to prohibit bargaining. And while Mr. O'Neill doesn't like Supreme Courts as far as courts, they are courts. They did confirm PERB. It wasn't some internal rubber stamp. It was a court that could have been appealed to the appellate division and stayed good precedent and well followed since 1997. This is only an issue for the city of Long Beach because despite being on clear notice since at least 1997, they decided to wait until they wanted to fire someone under Section 71 to decide how to do it. That's the only reason why there's any conflict with what seems to be the clear goals. Nothing prevented this from being fully addressed.
So there is this mechanism for resolving it?
Yes.
Use an arbitrator. Just a different question. Would our ruling here, if we were to go your way on these types of procedures, would it be limited to municipal employees and not state? because of the impact of the regulation, potentially?
I don't believe it'd be, unless you drafted it to so be so, I don't think it'd be automatically unchallengeable. But I think the better view of any ruling on Section 71 here would apply to both state and local municipalities, because although there are clear distinctions for the civil service law, they are not pertinent to the legal principle before this court, which is that the legislature needs to be explicit or inescapably implicit. So I would argue the better way to draft your opinion would be, but you do have the power to limit it to this case.
Thank you, Mr. Foyce.
Thank you.
Mr. Stober?
Your Honors, I would just like to use one word, Watertown. The Appellate Division Second Department decision, for all intents and purposes, reverses Watertown. Watertown, which dealt with Section 207, also said, you know what, legislative history is empty. There's no pre-termination procedures. Therefore, under the state's sweeping proposal of promoting negotiations, pre-207 procedures must be mandatorily negotiated. That has been the law ever since you promulgated this back in the day. What the Appellate Division is doing is saying, no, despite Watertown, we're saying that this is not clearly negotiable, even though it's the exact same scenario as Watertown.
Well, their only way around Watertown is by citing the regulations that everybody seems to think don't apply.
Well, you know, the thing with those regulations are, they're a guidepost, but under Newberg and the other case law that this court has determined, you can't use a regulation to overturn a specific statutory obligation.
Well, I think
And if this court,
thought that the parties also agreed the regulations applied, if at all, only to state employees, not municipal employees, and so
Well,
they're irrelevant here.
that is true, that this regulation only applies to state employees, and they're not before us here, so like Mr. Foy said, if you specifically carved it out in your decision, well, then you carved it out. But if you leave it, I guess it's a fight for another day, and the next time I'm representing state employees and one
So
of
if
my
I'm,
other views.
if I'm understanding your response, you're saying, okay, well, maybe the plain text makes it obvious that the regs only apply to state employers, but whether or not that could withstand challenge is not something we have to decide now.
Not today, no, Your Honor. Unless the court has any other questions, I rely on our briefs and the oral argument and the Watertown case. And I thank you all and congratulations on 175 years. Let's go for another 175.
Thank you, Mr. Stover.